This is case number 21-169-711. This is Denise Galloway versus Progressive Michigan Insurance Company. All right, today is date time set for a pretrial conference regarding this matter. Your appearance for Galloway, please. Your appearance for Progressive. Before the parties on Galloway versus Progressive, either side is here. Please say something at this time. All right, the court's going to pass on that matter. The court now calls for case number 150013. This is Visiting Angels Living Assisting versus Kenneth Wesley. The matter is before the court on an adjourned date for review. Your appearance at this time for Visiting Angels, please.
Good morning, Your Honor. I'm Jim Washington, P42503, on behalf of plaintiff.
All right, thank you, Mr. Washington. Good morning to you. Madam Counsel, your appearance at this time, please. Ms. Jefferson?
She's on mute. Okay, there she goes. I see her. Okay.
Ms. Jefferson, if you're hearing me, I need you to come in now. Your appearance, please. All right, Counsel, why don't you go ahead and update me? I know I had this on a short leash. Did we get some progress done here?
Yes, Judge. Slight progress. So it's been at least beneficial. I'm not sure if we're there yet, but it seems as though we do have an offer on the table. Hopefully, we may be able to codify it into some type of language that we can all agree upon. And that's about where we're at this point, Judge. So I guess my tenor has changed slightly to say that maybe we won't just be so hasty to ask for trial. We'll leave it to the discretion of the court. Maybe a little more time, we might be able to work it out.
All right, so I'm going to go ahead and hold off on that trial date that was requested. It looks like some progress is being made towards possible resolution in the matter. So I'll go ahead and set it over. I know this has been around for a while. I'm going to go ahead and set it 30 days out for the next action date. That will be an adjourned review date. That date's going to be June 22nd. 6/22/22, and that's going to be at 10 o'clock a.m. 6/22/22 at 10 o'clock a.m. And I'll review the matter at that time. Hopefully it's resolved, and we'll see where things are. It looks like progress is made. The court adjourns the matter with good cause shown.
Always good to see you, Judge, but maybe we'll be able to avoid that if we can put it in writing. You won't have to see us.
Thank you, Judge. I'm sorry for not putting my appearance on. Hey, Judge Jones number called me. What Thomasine Jefferson on behalf of Mr. Wesley.
All right, thank you. Well, I won't hold it against you that you made them a priority today, but we'll see. We'll see.
I left them and told them I was coming to you, and then they called me like, come back. Thank you, Judge.
All right, thank you. Have a good day now.
You too.
You too. Bye-bye.
All right, this is case number 21-161-349. This is Michigan First Rehab versus Nationwide Mutual Fire Insurance. The matter is before the court. This is set on for review on today's date as well. Your appearance for the plaintiff, Michigan First, please.
Good morning, Your Honor. Connor Clardy, P4485, appearing on behalf of the plaintiff, Michigan First Rehab.
Thank you, Mr. Corley. Good morning to you, sir.
Good morning, sir.
Now for Nationwide Mutual and Fire Insurance, your appearance at this time, Counsel.
Good morning, Your Honor. May it please the court, Matthew Scott appearing on behalf of defendant Nationwide, P80241.
Thank you, Mr. Scott. Good morning to you as well, sir. I did send over for review. It seemed that there was a deposition that was outstanding, and that the parties were moving towards getting that matter taken care of. And then perhaps there'll be some discussions as to possible resolutions herein. Somebody update me at this time.
Well, if I may point out to the court, you might recall that we were just here about 2 weeks ago this is in a sense, I guess, a follow-up pretrial conference. Don't mean to speak at all for brother counsel, but we had discussed that plaintiff's counsel in this lawsuit would be moving or was considering moving to withdraw, as there has been another lawsuit filed by a different firm in 31st District Court for the exact same claim and plaintiff. So that's where we're at today, Judge. And I would, we of course, we have not seen plaintiff's counsel has not yet moved to withdraw. But under the circumstances and of course, with the court's discretion, we would ask this case to be dismissed short of filing an additional motion.
Thank you, Mr. Scott. Ms. Clary, it's getting more and more interesting every week.
Yeah, I know it, Your Honor. So a couple things I would ask. So I was going to file a motion to withdraw, and I still planned on filing a motion to withdraw today. However, I would be more than happy to do an oral motion to withdraw on the record for Your Honor. That way we can give my client an opportunity to at least address this lawsuit in terms of how they want to proceed with it. I can't get into the details of my communications with my own client, but if the court is willing, I could do an oral motion on the record to withdraw.
All right, and counsel, your oral motion sounds in the reality that it seems that you have a client who has hired another lawyer who seems to be advancing this particular claim in another jurisdiction. Is that correct, sir?
That is correct, Your Honor.
All right. Under those circumstances, I would certainly allow your withdrawal at this time. I'll grant the motion accordingly. One final question that I have in this regard is, to the best of your knowledge, counsel, is there another pending action in another court that seems to address the claims raised here?
You're asking me, Your Honor? I just want to be.
Yes.
Yes, Your Honor. There is, the best of my knowledge, there is another lawsuit pending in 31st District Court, as brother counsel has previously indicated. And it is being handled by the Rise Law Group.
All right, very well, very well. So what I'm going to do is on Mr. Scott's motion, I will grant your motion to dismiss this matter, be dismissed without prejudice, where it appears that there is a claim that is pending in another court. Obviously, the plaintiff would have the right to come back to this court and ask for reinstatement to the extent that this claim differs from a claim that is being made in another court. But this time the matter will be dismissed without prejudice, where there is sufficient information provided to the court that indicates that there may very well be another action that is pending in another court that encompasses the claims that are set forth in the matter that is now before this court. So the motion to withdraw is granted, and the motion to dismiss is granted. That dismissal is without prejudice under the circumstances as set forth on this record by this court. So.
Thank you, Judge. Would you like for me to submit an order, or will the court enter one on its own?
I better have somebody. I got a lot of stuff going on. I better have somebody go ahead and submit.
I'll submit an order, Judge. Let me go and take this one off the plate.
All right, I appreciate that, and that your order is going to encompass Mr. Flority's the motion, the order granting his motion as well. Correct, sir?
Absolutely, I can certainly do that, Judge, and I will make sure that the order reads that it is a dismissal without prejudice.
All right, thank you. And regarding, you can email that once you got it together, so I can get it right back to you. That the email address where you can send that is Latifah, LATIFAH .Hunter. Hunter is the last name. .Hunter at 3636th 36 districtcourt.org.
Got it. Thank you, Judge.
All right, thank you.
Thank you, Your Honor. Thank you, Your Honor. Thank you, Matt.
Have a good day.
All right, the board now calls case number 21-150058. This is Carlos Williams versus Metropolitan Group Property and Casualty Insurance. Matters before the court, set on for review on today's date. Your appearance for Carlos Williams, please.
Good morning, Your Honor. Richard Brewer, P31124 on behalf of Mr. Williams.
All right, thank you, Mr. Brewer. Good morning to you, sir. For Metropolitan Group Insurance, please, your appearance at this time.
Good morning, Your Honor. Monica Rossi, P61916, appearing for the defendant Metropolitan.
Thank you, Ms. Rossi, and good morning to you as well. I see that on a previous occasion, I did sign an order for this matter to be mediated. Tell me what's going on here. Somebody update.
Yeah, it did, Your Honor. It case valid for $12,000. I believe both parties rejected. We discussed the fact that I do have authority to settle for $12,000. Defense counsel this morning inquired as to whether my client would be willing to waive futures for some unspecified sum. I have been unable to locate my client this morning. His mailbox appears to be full, but I'm still trying to see if he's interested in waiving futures. That's where the state of our negotiations at this point.
Ms. Rossi, sounds about right at this time.
Yes, that's an accurate representation of where we are.
So to the best of your knowledge, Mr. Brewer, do you know if there is any ongoing treatment regarding this matter post the claims?
I don't know for a fact, Your Honor. I don't believe there is, but that's one of the matters I wanted to confirm with my client.
All right, so it looks like, well, it looks like if I set it over for a couple of weeks, that'll give time to at least see where you are, maybe get it resolved, but at least, you know, we'll have some finality as to whether or not it can be resolved.
I think so, Your Honor.
All right, so I'll bring it back on a short leash. We'll set that date over a couple of weeks now. That's going to be June 1st, 2022. And that's going to be at 9:45 a.m. June 1, 2022. Let's set for a review, and we'll see where things are at that time. Hopefully, you get it resolved. If not, we'll go ahead and set it up for a trial post that date.
Thank you, Your Honor.
Sounds good. Thank you so much.
Thank you. Good day to the two.
Good morning, Your Honor.
This is case number 21-16-2312. This is Credit Acceptance Corporation versus Yolanda Holman. The matter is before the court. Looks like plaintiff minute motion to enforce settlement agreement. Your appearance for the for credit acceptance, please.
Good morning, Your Honor. Naljat Francis, P72322 on behalf of plaintiff's attorney of record.
All right, thank you. Good morning to you, Ms. Francis. I'm looking now for Yolanda Holman. If you're on the Zoom, say something at this time. Yolanda Holman. All right, I'm looking for defendant Yolanda Holman living on South Kane Street in the city of Detroit. If you're on the Zoom anywhere, please say something at this time. All right, counsel, it looks like the defendant is not present. This is set for 10 a.m. It's now 10:14. You have a plaintiff amended motion to enforce settlement agreement. Tell me what that's about now, counsel.
Your Honor, we previously appeared before the court at a prior hearing date and agreed to a consent judgment with some payments, and we sent that to the defendant after the hearing, and it has never been returned. So that's why we are asking that a judgment be entered with those terms to be able to close out this file.
All right. Given that such a settlement was indicated on the last occasion when the defendant was here, given that the defendant has not appeared at this time, the court will grant your petition for enforcement of the settlement agreement. And I do see that agreement was in the nature of a judgment entering for $10,634.07 with an agreement to commence payments immediately at $250 per month. That was to begin March 1st. Now your amended, let's see, your amended motion does not have a judgment attached. What is the concern as it relates to the amended motion?
I am not sure, Judge. The payments are actually $200 a month. But in my motion, there is a judgment attached.
Okay.
So
all right.
I don't think I have the original motion.
I do have the original motion, and the original motion, the difference is that the original motion had $250. The amended one has the $200. That's the difference.
Okay,
Right, so-
sorry about that.
I will enter the judgment. But one of my concerns is that the judgment requires commencement of payments on 3/1. And so it would seem to me that the defendant would be in default already. And I guess I wouldn't want to start the judgment out in that way. So my thought is to amend the proposed entry with a commencement date of June 3rd instead of the March 1st.
I would have no objection.
All right, so I'm going to insert the June 3rd date, 2022 as a commencement date for the $200 per month, and I'll enter the judgment accordingly. Thank you, Counsel.
Thank you, Your Honor.
Good day to you.
You too.
So,
Okay.
Oh, no.
Okay.
All right, this is case number 21-171768. This is Auto Club Group versus Cedric Fields. The matter is before the court. Looks like on an application for entry of default judgment. I do have it set up for a hearing on today's date. For Auto Club, your appearance at this time.
Yes, thank you, Your Honor. Dylan White, P80755 for Auto Club Group.
All right, thank you, Mr. White. Good morning to you. I'm looking now for hold on one second. I'm looking for Cedric Fields. Look like I also have in this file Deandra Fields. All right, very well.
Yep,
Go ahead.
I'm
Go ahead.
Deandra Fields.
All right, thank you, Ms. Fields. All right, and good morning to you.
Good morning.
All right, so it looks like there's an application for entry of judgment in this matter for the total sum of $3,813. And this claim seems to be brought as to Ms. Deandra Fields, but it also seems to be brought as it relates to Cedric Fields as well. Counsel, tell me what this is about, sir.
Your Honor, this is an auto subrogation claim for a motor vehicle accident that happened on or around September 16th, 2020.
All right. And ma'am, I received a note that you sent, and your note that you sent Ms. Fields says you're not guilty. This is not a criminal case, but it said several times that you're not guilty of something. So what's going on here, ma'am?
Well, basically, she ran into my car. So she pretty much T-boned my car and I had to come out of pocket over $1,000 for my damages to my car.
All right, and when you say she, are you talking about Deanna Lucas? Is that who you're talking about?
No, Deanna Lucas, that's my mom. I'm talking about the other, like his insurance.
Okay, all right. Okay, so counsel, why is Auto Club indicating that they are pursuing Ms. Fields in this matter? She says that she was struck by a vehicle. What's going on?
According to the report we received from Auto Club, they are saying that Deandra Fields was negligent in this matter because it wasn't her turn to move through the four-way stop.
All right. I don't see, and so do you have a copy of the accident report? Because I don't see that attached to the file.
We do not have a copy of the accident report, Your Honor.
All right, so, all right, ma'am. So what's going to happen here is that it does seem to be a disputed issue. The plaintiff is suing on what's called a subrogation claim, where they Auto Club paid for the repairs on the vehicle of their insurer, and if somebody else was the cause or partial cause of that accident, under the law, they would have a right to seek reimbursement from that party. Now, was your vehicle insured? Did you turn this lawsuit over to your insurer? Was your vehicle insured at the time?
At the time, it wasn't. I was looking for a different insurance. It lapsed.
And so were you in fact the owner and the operator of that vehicle?
I was driving it. It's my car, but it's in my dad's name though.
Okay. So what's your dad's name?
Cedric Fields.
Okay, that's what I'm trying to piece these names together. Okay. So
Yeah.
he was the owner of the vehicle, but you were the operator.
Yes.
All of those things have legal implications. That's why I'm asking you those kind of questions.
Okay.
Council, now I'm looking for the proof of service documents with regards to this matter, because I don't have Mr. Cedric Fields here. I do see the service regarding this Ms. Deandra Fields.
Yes.
I see a proof of service for Deanna Lucas.
Yes, it looks like December 27th, 2021. All three were served personally at the same address.
Okay, I don't see a proof of service for Cedric Fields, not in the court's file. I see a proof of service for other two individuals, for Deanna Lucas and for Deandra Fields. I don't see a proof of service for Cedric Fields.
Okay.
I have another jacket here. Let me look at this other jacket. Just a moment. I still don't, I see a certificate of mail. And that's a certificate of mailing of the default question entry regarding Cedric Fields, but I do not see a proof of service document on Mr. Fields.
That's something we can get you, Your Honor.
Yeah, what I'm saying is that that's not in the file, and I know that you were requesting entry of judgment with regard to Mr. Fields. Hold on one second. All right, yeah, okay, now I'm seeing, okay, here it is, right here, I believe. Okay, I do see a proof of service for Mr. Fields now. That escaped me. So ma'am, here's what it looks like, counsel, that in each of these matters, someone filed a document saying Andrew Fields is not guilty. Miss Fields guilty and Lucas is not good. I guess that's intended to be a response, but it doesn't look like Mr. Fields is on that. Well, maybe it is.
Yeah, it's hard to tell, Your Honor.
Well, you said what I didn't want to say. Yeah, that's a good way of putting it. It's kind of hard to tell here. All right, and our notice from the court only went to, it looks like it only went to Ms. Field. The Andrew Field. Okay. All right. So the police, the accident report is going to be very telling in this case as to what occurred. Because what happens is that the accident report positions vehicles a certain way based upon what the accident reconstruction is, or the officer that came to the scene, what they position, how they position the vehicles based upon whose fault they believe it was. So position number one is typically the car that's placed as the at-fault vehicle in a particular occurrence. So I don't have the police report. That would give some insight into what the police may have thought occurred at the accident scene. Have you seen a copy of the police report, ma'am? Yeah, I'm asking you, ma'am.
No, I'm sorry. There was no police report. No police officer came to the scene.
Okay. Did anybody go and file a police report afterwards, to your knowledge?
No. All I have is pictures of the dent. Like, I have pictures of her car and my car.
All right.
Oh,
Counsel?
looks like the insured attempted to file a police report the next day,
All right.
but it looks like there wasn't one issued.
Okay. All right. Well, that kind of resolves that aspect of it. All right. So then, what has to happen then is that the court will likely have to conduct a hearing regarding exactly what occurred in this matter in order to get this matter resolved. Now, what I don't have is I don't have an actual answer filed to the complaint. And Ms. Fields, together with your father, Mr. Cedric Fields, and as well as the other person, I believe you said that's your mother, correct?
Dina Lucas, yes.
Yeah. So was her name on the vehicle as well? Is that why she's here, or do you know?
Yes, they're like, it's like she was like the co-signer on the car.
Okay. All right, and, okay, very well. So yeah, I understand why she's in this also. So what needs to happen is somebody needs to file an answer It seems like you're wanting to defend this, but you have to file an answer to do that. And that answer could be filed by all three persons, so that this can be properly set before the court. And the way that you do that is there is a complaint that was served on each person, and that complaint is the reason that you're here. That complaint has several different claims to it, 1 through 23. And essentially what you would need to do is to file something with the court that gives an answer to that. Yes, no, not sure, something on each of those items. And then to state as a part of your answer what your claim or your defense is to this case. Now, you told me some things, but you kind of need to put that in writing and send a copy to the court as well as to Mr. White, right? You understand what you need?
I'm sorry.
Go ahead, I'm listening.
How do I go about, like, where do I find that type of stuff to file it?
All right, you can do that on the second floor of 36th District Court. They have a form there that you can fill out. That's called an answer. That's what you want to do, is you want to submit an answer. I'm giving you time and opportunity to do that because you did put something in writing. I want you to follow the court rules by putting something more specific in writing. All right. Now you can do that on the second floor. Also, you can go online and you can type in Michigan court forms, for example, and you can find a form on there that's called answer to a civil complaint. It's an answer form. And you could use that form to write out what your answer is and then bring it down to the court and file it with the court on the second floor. Send a copy to Mr. White. And then the address that you send that to is on the complaint form. The complaint that you receive, you would you would send the answers to address in Grand Rapids. You would send a copy to that address and file a copy with the court. Okay.
Okay.
So what I'm going to do is I'm going to set this up for a pretrial conference like 30 days from now. But I'm going to give you the next 3 weeks to get your answer in on this matter. So you have 3 weeks to do that. So today being the 17th, I'm going to give you until the 7th of June to get your answer in. Okay, so you should do it way before then, but you got to have it in by the 7th of because if it's not in by that date, then you're going to be in default on this case. They'll get the judgment automatic. So make sure you respond to the complaint, put something in writing, and file it with the court and send a copy to Mr. White by that date, the 7th of June. Your next court date in this matter is going to be June 29th. All right, can we do the 28th? 28th, yeah. All right, June 28th is going to be your next court date. You're going to get a notice from me with that date on it in the mail, but you can write it down. It's June 28th, and that's going to be at 9:45. June 28th at 9:45. Now, June 7th is when you got to get your answer filed. Okay. Okay. We'll take a look at everything at that time to make a decision about which. All right. Anything at this time, Mr. White?
Just for clarification, Your Honor, we are setting aside the default for Deandra Fields at this time. As to the other two parties, are the defaults still staying in place?
I didn't know that there were defaults in place, but wherever there are defaults, they're set aside at this time, pending the filing response of pleadings by the 7th of June. So I'm setting them aside because I received that handwritten note that seems to be answering or trying to answer on behalf of all three persons. I'm going to go ahead and set the defaults aside at this time. And I'll allow for an answer by the 7th of June regarding those three individuals. And then I'm setting the next court date, as I've indicated, and the notice on that court date will go out to Ms. Fields and the mother and father as well. So everybody's going to get a notice for that date. and then we'll take a look at everything and see which way this case should go.
Okay, excuse me, Your Honor.
Yes.
When I go, like when I fill out the answer or whatever, do my mom and dad have to come and do the same thing as well, or is it just me?
If you want to keep them from having a default judgment against them, then all three should be included in the answer. Okay, so you put all their names on it, you get all of them to sign off on it if it's the same answer. Okay,
Okay.
all right.
All right,
understand
thank
how
you.
that-
Yep,
All right, thank you, and make sure you get that in by June the 7th. It's gotta be filed by that date, timestamp and everything by June the 7th. All right, I'll see you on June 28th.
okay,
Thank you, Your Honor.
Thank you, Council. All right, good day to both sides.
thank
All
you
right.
too.
And once again, in regard to 9711, Denise Galloway versus Progressive Michigan Insurance, if you're on the Zoom, someone, please say something at this time.
Hey, Mr. Clark-Hurdy is, or whatever his name, Clark-Hurdy was her attorney, but he left. But he's not on there anymore.
All right, it seems that neither party is present on this matter. I did allow for an order of discovery that allowed discovery through today's date. We're gonna reset the date on this matter, set it to pre-trial conference. I see a Karan Estelle. If you have matters before the court, please say something at this time.
Yes, sir. Yep, right there.
Yeah, what do you have in front of me, sir? What case number?
Okay. 12207501.
Yeah, what kind of case is it? What are you in court for?
It says for a paintball gun.
Did they tell you the judge, sir?
Yeah,
What's the name they gave you?
Blount C. It says Blount C.
Christopher Blunt, when he was here, whoever took over his case, I think it's Evans.
Yeah.
Evans took over his case.
Okay, so sir, that courtroom is 334. I'm gonna give you some information that's gonna get you into the courtroom. It's gonna be 90, okay?
Okay, wait, hold on, let me get a pen. Hold on.
Yes, sir.
What is it?
360 334 0000.
Repeat that.
360
Mm-hmm.
334
Mm-hmm.
0000. That's the meeting ID number right there for you.
Okay, all right, thank you.
Yes, sir. Good day.
You too.
Hmm.